title, The Quiet Force Behind the Sweater. He thought she was just another timid attorney trying to find her footing in a world too sharp and relentless for her kind. Judge Harrison Whitaker had seen hundreds like her, young, idealistic, overdressed, or sometimes pointedly underdressed to appear humble. But in his view, they were all the same, amateurs in a courtroom they didn't understand. So when Maren Ellis walked into his courtroom that morning in a plain beige sweater and scuffed black shoes, her brown hair pulled into a no-nonsense bun, he barely hid his disdain. "Are you actually prepared to handle this case, Ms. Ellis?" he drawled from the bench, amused, expecting her to stammer. But the moment she opened her mouth and began quoting rulings older than the courtroom itself, his smile flickered and vanished. It hadn't been an accident, none of it. Not her appearance, not her mannerisms, not the slightly faded leather briefcase with worn brass clasps. Everything about her was calculated to invoke dismissal. And it was working. That morning, as sunbeams crept past the thin curtains in her modest Boston apartment, Maren had stared at herself in the mirror. 38 years old, respected civil rights litigator, veteran of countless legal wars in Massachusetts and beyond, and now the woman about to walk into a trap she'd carefully set herself. She removed her pearl earrings and set aside her sleek navy pantsuit. Instead, she slipped into a plain beige sweater and loosely cut black pants. Her contacts were replaced with dated prescription glasses. She didn't want anyone in the courtroom to see Maren Ellis, the feared litigator who once dismantled a housing discrimination case in under 2 hours before the First Circuit. She needed them to see someone else entirely. "This has to work," she whispered to her reflection, adjusting her frames. 3 months earlier, Maren had been approached by community organizers representing Ashwood Terrace, a small retirement community nestled within Easton Square, a low-income district often overlooked by city plans and developers alike. A real estate behemoth, Hollingsworth Holdings, had their sights set on the area. Luxury townhomes were planned to replace the modest brick buildings. Families, seniors, veterans, dozens of vulnerable tenants were to be displaced under the guise of progress. The legal team before Maren had already failed spectacularly. The case had been tossed with contempt by none other than Judge Whitaker himself. His record was notoriously one-sided, especially in civil cases involving corporate interests. When it came to housing, he leaned heavily in favor of property owners. When it came to female attorneys, his courtroom bias was palpable. "If he sees me coming in like I always do," Maren had told her friend and fellow attorney, Diego Vaughn, "he'll have made up his mind before I open my mouth." "You're going to hide who you are?" Diego asked skeptically. "I'm going to let him assume who I am." That was the difference. She wouldn't lie, wouldn't manipulate the court, but she would allow Whitaker to dig his own grave with the shovel of his assumptions. As she packed up her case files and kissed her aging Labrador goodbye, a text lit up her phone. It was from Evelyn Poe, a 76-year-old retired librarian who had become the face of the Ashwood Terrace resistance. "We're counting on you, sweetheart. Please don't let them take our homes." Maren stared at the message, a dull ache filling her chest. This was never about prestige. It was about lives, about dignity. At the courthouse, no one gave her a second glance. She looked like any overworked public defender trudging into another grueling day. The opposing attorneys, 4 of them, all in gleaming suits, barely registered her presence. Their lead counsel, Matthew Layton, a name that rattled off tongues in high-dollar legal circles, leaned toward her with a patronizing grin. "Are you the assistant?" "I represent Ashwood Terrace," she answered coolly, offering no further elaboration. He chuckled and returned to his notes, not bothering to hide his amusement. Inside the courtroom, Evelyn and a handful of other senior residents sat behind Maren. Their clothes were clean but worn, their expressions anxious. Evelyn reached forward and squeezed Maren's shoulder. "Thank you for doing this. We couldn't afford to lose again." Maren nodded gently. "Sometimes, it takes the unexpected to make someone pay attention." "All rise," the bailiff called out. Judge Whitaker strode in, his dark robe billowing slightly, white hair combed back meticulously. His gaze landed on Layton first. He nodded with a trace of familiarity, then on Maren. A flicker of confusion, then narrowed suspicion. "So," he said as he sat, "new representation for the plaintiffs. Let's hope we don't waste the court's time today." Maren gave a small nod, her expression unreadable. "We're prepared to proceed, Your Honor." Layton began his case like a man who'd already won. His presentation was flawless, reams of documents, charts, legal citations, all delivered with the charisma of someone used to getting what he wanted. He talked about revitalization, economic growth, the irrelevance of nostalgia. When he sat down, Judge Whitaker actually applauded. Thank you, Mr. Layton. Clean, and to the point. Then his gaze turned to Marin. Ms. Ellis, your response. Marin stood slowly, adjusting her papers in a slightly clumsy manner. Your Honor, she began with a calm, almost hesitant voice. Ashwood Terrace has provided stable housing for over 60 residents for the past 2 decades. These individuals have. Ms. Ellis, the judge interrupted. This court is not interested in sentimental appeals. If you have a legal argument, please get to it. She blinked, as if startled, and nodded. Of course. The residents contest the zoning change. Several tenants never received the legally required notifications for public hearings. Layton stood smoothly. We have signature confirmations for every unit, Your Honor. Indeed, Judge Whitaker muttered. Do you have anything more, Ms. Ellis? Marin pretended to fumble through her papers. Yes, Your Honor. There's also the matter of Ashwood Terrace's eligibility for historical protection. Whitaker pinched the bridge of his nose. This again? No, sir, she said. Not under the same argument. I'm invoking the Beckett versus Hanover precedent from the Second Circuit, which outlines a set of 5 criteria for emergency historical review. The judge's eyes lifted from his notes. That case was federal, Ms. Ellis. This is a state matter. It was later cited by Massachusetts in Marley versus Crestview Holdings. Page 213 of the ruling affirms applicability in cases involving elderly residents and historic land usage over 2 decades. Layton scowled. Your Honor, that's a stretch. Marley involved a registered landmark. Ashwood is not. Marin's voice sharpened. Respectfully, it doesn't have to be. Marley expanded the scope to unregistered but eligible sites under emergency designation review. I've brought documentation supporting this claim. She handed over a packet. Whitaker scanned the top page. Then another. The courtroom grew quiet. Slowly, he set the packet down. You're surprisingly prepared, Ms. Ellis, he muttered. Where did you say you studied law? I didn't, Your Honor. But I'm a graduate of Yale. Class of 2007. That got his attention. Layton frowned. Wait. Marin Ellis? As in Ellis versus Commonwealth? Marin inclined her head. Yes, that was me. Judge Whitaker leaned back slowly, expression unreadable. Well, proceed, counselor. For the next 45 minutes, Marin dismantled the opposition's case with precise citations and an encyclopedic memory of preservation and zoning law. She presented maps, affidavits, and state legislative reports. She invoked the Jackson Doctrine. She cited cross-jurisdictional interpretations from appellate courts. The judge didn't interrupt once. By the time she finished, the courtroom felt transformed. Evelyn and the others sat straighter. Layton looked visibly rattled. When Judge Whitaker called for a recess, his tone was subdued. In chambers, he addressed both attorneys quietly. Mr. Layton, were you aware of the Marley citation? We considered it not applicable, Your Honor. Apparently, you were mistaken. He turned to Marin. You presented one of the most comprehensive arguments I've heard in a housing case. Why the subdued approach? Marin met his gaze. Because I needed you to listen. Not to me, but to the law. Back in court, Judge Whitaker issued a preliminary injunction blocking the demolition. He ordered a full review of the zoning changes and preservation eligibility. As Evelyn wept quietly, holding her neighbor's hand, Judge Whitaker added, This court acknowledges the complexity of this matter and commends Ms. Ellis for her diligence. Layton said nothing. There was nothing to say. Outside, cameras flashed. A reporter called out, Ms. Ellis, did you really disguise your background to make a point? Marin paused. I didn't disguise anything. I just allowed the court to reveal itself. As she escorted Evelyn and the others down the courthouse steps, the old woman whispered, You made him see us. No, Evelyn. You made him see you. In the weeks that followed, Judge Whitaker became notably more respectful to female counsel in his courtroom. Marin returned to her practice, sometimes in tailored suits, sometimes in beige sweaters. It didn't matter anymore. Because she had proven something timeless, that brilliance doesn't need to shout, and that even the most entrenched systems can be shaken by the quiet strength of someone underestimated. And on mornings when she stood in front of her mirror before court, she no longer questioned what to wear. She knew her power wasn't in her appearance, it was in her mind, her convictions, and the courage to be underestimated. Because that, she realized, was her sharpest weapon of all.